liar here. We'll see. Today, I want to press upon you how easy it is to destroy these sons of bitches. All right? And we will get back to the 1099As and how important they are. But as you know, I study an array of quote-unquote purported law, from the Magna Carta to the Bill of Rights to the Declaration of Independence to the Federalist Papers. All of this has some importance and significance in one way or another. And then we get into like the law of merchants, contract law, so on and so forth. And then we have our constituents, or a good group of friends that all bounce ideas off of each other. We're all trying different things. You've got Mr. Anonymous, Malika, Justin Nolan. There's a number of them out there. Some of them I don't even mention their name. I mean, David Straight's out there. I think he's doing the best of his ability. He's doing great work trying to inform the general populace, right? Because the truth is, what has happened in this nation is we fell asleep at the wheel and haven't kept our public servants in line, in check, all right? And that's our problem. That's our fault. But we can correct that, all right? And I'm going to run through it today about how easy it really is to lynch these motherfuckers financially. Because, you know, it's kind of unbecoming of a righteous man to go tie somebody up to a tree by a saddle horn and string them up from dusk till dawn, or vice versa, dawn till dusk, right? We really don't want that blood on our hands because these thieving, lying, looting, pandering pieces of shit can't seem to control themselves. So, first off today, what we're going to start with is the judicial canons that the judges are bound by in every state, okay? Your state, the language used within may differ or vary to a degree, but every state has judicial canon laws for judges, okay? And this is if we're going to string them up financially and lynch them, because we should, all right? And you get a couple of these bastards in a state and you fucking cinch them up financially, and the rest of them will fall in fucking line. That's a guarantee. Because nobody wants to lose all their precious fucking possessions. I myself don't give a shit about materialistic possessions, but I can guarantee you these motherfuckers do. All right? They've made a lifelong habit, a habitual offenders, to steal your securities and unjustly enrich themselves, while all avoiding or having plausible deniability that there's a conflict of interest in any way, shape, or form. But I'm here to show you there's always a conflict of interest with these motherfuckers, because they're administrators, not judges, all right? And we can get into the findings of the Senate House report that did an investigation, hired investigators to study the American Bar Association, the Bar Association in general, finding that they were a communist party hell-bent on destroying the American way of life. It's all been published. It's out there. It's in the Library of Congress. You can look it up. All right, this isn't just shit that I come up with in my fucking head. This is stuff that I've been directed to read by very intelligent people whose intelligence far supersedes mine. Maybe their intelligence doesn't supersede mine. Maybe they've just been on this planet a little longer and awake a little longer and did the due diligence prior to me coming along and discovering, hey, Watson, something ain't fucking right here. All right? So, let's get into these canons. For Nebraska, subsection 5, 302.1, giving precedence to the duties of judicial office. All right? The duties of judicial office as prescribed by law, okay, and this is their shit. It doesn't apply to us. It applies to them. Okay? If they create it, it binds them. Shall take precedence over all of judges' personal and extrajudicial activities. Comment. To ensure that judges are available to fulfill their judicial duties, judges must conduct their personal and extrajudicial activities to minimize the risk of conflicts that would result in frequent disqualifications. See canon number 3. Number 2. Although it is not a duty of a judicial office, unless prescribed by law, judges are encouraged to participate in activities that promote public understanding and of confidence in the justice system. All right? Now, When you're pointing out to an alleged judge, a ministerial administrator, hell-bent on fleecing your estate to unjustly enrich themselves, that you're invoking the Sixth Amendment, the right to face the accuser, and they say, well, it doesn't say that. You're reading it incorrectly. It says the right to face a witness. Well, let me ask you something. Would the accuser be a witness to the events that transpired? Yes, he or she would be. But there's a problem in these lower courts. Yes, sir, Bob. These sons of bitches are alleging that this is a criminal claim or complaint, but in order to constitute a crime, there must be somebody who has substantially suffered loss, damage, and dare I say injury. Injury is more of a legal thing. Harm, damage, and loss. All right, and it doesn't even have to be substantial. Remember, your rights can be violated without somebody even touching you. Okay, a custodial arrest is a violation of your rights, absent a due process of law, absent of a claim being brought forward under the pains and penalties of perjury, verifiable and deposed or with two witnesses. All right, so you just being stopped on the side of the road is a violation of your rights, and it can cause harm, damage, and loss. It doesn't have to be physical bruises. You didn't have to be tased, pepper sprayed, beaten into submission. None of that shit has to occur in order for you to sustain harm, damage, and loss. So, according to the judicial canons here in Nebraska, that the judges are encouraged to participate in activities to promote public understanding, all right, to refrain from seditious behavior and causing insurrection in the communities, which is a major no-no. When you come into a court and there's a learned man before you and you're an alleged judge, you have a duty to make sure that public tranquility and transparency clean across the fucking board is had. But not just with a learned man, with any motherfucking man, period, all right? Let's get on to canon number 2. Impartiality and Fairness. Okay, this is canon subsection 5302.2, Impartiality and Fairness. A judge shall uphold and apply the law, quote unquote, but we need to find out what jurisdiction we're in. What law are they upholding? What law are they bound by, okay? Canons come from ecclesiastical law, handed down from the Roman fucking Vatican. That's what canon laws are. All right, so for these asshats to fucking sit there and tell you that foreign influences on this court will not be had, we will not tolerate that. Where the fuck did you get your canon laws from, you dumbass? Right? So, and shall perform all duties of judicial office fairly and impartially. Impartially meaning that they don't have a conflict of interest in here. They are a non-biased third-party individual set to rule on the matter who's learned, allegedly, in law. All right? Comment. To ensure impartiality and fairness to all parties, a judge must be objective and open-minded. Are they very fucking open-minded when a motherfucker walks in, alleges to be representing a fictitious entity using false and fictitious misnomers, unregistered DBAs, and not proving their credentials on the record? I'm just saying, I mean, fuck, Big Bird can sue you at this fucking point, right? I mean, Big Bird. It's an imaginary fucking animal on Sesame Street. But by their conduct that has been exhibited throughout the times, throughout the ages, it's pretty fucking evident Big Bird can shove his big yellow dick up your ass, all right? And the judge just can go, well, you know, it's just what it is. We're allowed to presume and assume Big Bird's alive. Even though everybody knows in reality Big Bird doesn't fucking exist, all right? Follow me on this. Number 2, although each judge comes to the bench with a unique background and personal philosophy, okay, philosophy not law, that's ideology, that's thinking, I'm glad they're fucking thinking. The problem is that the tie always goes to the fucking runner. It always goes to the American people, and they're not doing that. Why? Because they're incentivized to fuck you over. A judge must interpret and apply the law without regard to whether the judge approves or disapproves of the law in question. First of all, the law will never ever be in question because the law is pretty simple. Do no harm, bear false witness against no one, take not what not belong to you, right? I mean, law is so simple, a fucking kindergartner understands this shit, okay? Number 3, when applying and interpreting the law, first of all, the law is not for interpretation. Thou shalt not fucking murder. It doesn't need an interpretation. If you're out there maliciously plotting and planning to cause somebody harm, injury, damage, or loss, you are guilty of a fucking crime. Well, only when you act upon it. You can think about it all fucking day long. Until you act upon it, there is nothing. They may hammer you for conspiracy if they figure out what you're thinking about, but until you give action to your thought process, it really doesn't constitute a crime, all right? A judge sometimes makes a good faith effort of a fact or law. Okay, well, a good faith effort isn't good enough. That's not good faith, that's bad faith. If there needs to be clarity shined on the record, then that judge has a fiduciary obligation to get clarification, right? Errors of this kind do not violate this rule. Again, it's a rule, not a law. Number 4, it is not a violation of this rule for a judge to make a reasonable accommodations to ensure pro se litigants, that's a temporary license to be one of the Bar Association bureaucrat rats that practice communism, okay? You don't want to be pro se, all right? You're a sojourner, you're sui juris, all your rights intact, and you can give them a big one of these and say, Derek told them to say hi, right? The opportunity to have their matters fairly heard, huh? On the other hand, judges should resist unreasonable demands for assistance that might give an unrepresented party an unfair advantage. Well, there's a problem with this whole racketeering RICO scheme they got going on, folks. The opposing counsel allegedly, purportedly working on behalf of a client, right? The state of confusion, whatever state that may be, doesn't exist. Okay, and they're giving an unfair advantage to their Bar Association member, for which they are still participating members of the American Bar and the Nebraska Bar Association, or whatever association they're part of. They have signed an oath and an allegiance to that fucking club. Okay, and they've never rescinded or terminated the contract between them and the Bar Association. In fact, the United States Supreme Court has made it abundantly fucking clear, in order to be a judge in this country, you first have to be a good standing member of the American Bar, or the Bar Association for the state you're in, for no less than 5 years of good fucking standing. Okay, so you've had to be a lying, looting, pandering piece of shit for 5 fucking years before you qualify to be an expert in fleecing the American people under a communistic manifesto, hell-bent on unjustly enriching themselves, their brotherhood, and their card club carrying fucking members. All right, so let's move forward. I'm just kind of going to give it to you hard hitting today. All right. Canon Law, Subsection 5, 302.3, Bias, Prejudice, and Harassment. A judge shall perform the duties of a judicial office, including administrative duties, without bias or prejudice. That's fucking laughable. A judge shall not, in the performance of judicial duties, by words or conduct, manifest bias or prejudice, or engage in harassment, including but not limited to bias, prejudice, or harassment based upon race, sex, gender, religion, national origin, ethnicity, disability, age, sexual orientation, marital status, status, or political affiliation, and shall not permit court staff, court officials, or others subject to the judge's discretion and control to do so. So when they're up there on the bench mocking you for quoting the Constitution and demanding that your rights be upheld, which is what he's supposed to do. He's in a position of trust, okay? And you need to call him out on this bullshit. They're in a position of trust where they are supposed to advocate and fight for you, because the tie always goes to the American. The tie always goes to the man. The benefit does not get extended to the fucking corporation, all right? Or their private bar club. That is not how this is supposed to work. All right. C, judge shall require lawyers. Oh, and let's get back to this. Let's get back to this harassment shit. Are you being harassed when you're bringing up valid points and they're saying, if you continue to bring up the Constitution in this courtroom, we will issue contempt of court? Is that threat, duress, and coercion? Is that extortion? Are they attempting to prejudice your case? Are they in cahoots with the prosecutor conspiring against your unalienable rights to unjustly enrich themselves based upon the securities that have been manifested in the performance bond, bid bond, payment bond, penal bonds, and penal sums? Is this motherfucker really working in the interest of the American people, or is private bar association fucking cronies? That's a question you need to ask yourself. Now, there are a number of things I can point out on a fucking subpoena, on a summons, on all kinds of documents, okay? When you bring up the fact that no warrant of attorney has been presented in material fact and evidence on the record that this son of a bitch representing the imaginary plaintiff even has a fucking contract between him and his fucking plaintiff, that right there is grounds for a fucking vacate dismissal, all right? Period. In all rights, titles, interest, dividends, derivatives, debentures, settlements, general tangibles, general intangibles, child security, trust, residual assets, rents, profits, proceeds belong to you, the rightful heir and beneficiary and entitlement holder of said securities that were generated in bad faith, not in fucking good faith, in bad faith. How do we prove that? Well, the lawyer has no firsthand knowledge of the facts, and he wrote up a statement alleging that there was probable cause for some judge, some half-wit fucking nincompoop who's educated, to go ahead and sign off on a probable cause affidavit and warrant. Okay? Now, the problem with that is, under Trinsley versus Pagliaro, anybody that doesn't have firsthand perfected superior knowledge willing to testify under the pains and penalties of perjury and verify their fucking claim with firsthand superior knowledge has no fucking standing in the court. None. Which means that bullshit lion, looting, pander motherfucker that works on behalf of the county, who's allegedly bringing suit on behalf of the state, is in fact an egregious liar, and the court cannot reach a summary judgment based upon fucking hearsay. Get fucked and kick rocks, all right? Let's go on, because we're really focusing on the judge. I'm going to hammer some asses here shortly. We're going to have so much fun with these fucks. All right, C. A judge shall require lawyers in proceedings before the court to refrain from manifesting bias or prejudice, or engaging in harassment based upon attributes including but not limited to race, sex, gender, religion, national origin, ethnicity, disability, age, sex orientation, material status, socioeconomic status, or political affiliation against parties, witnesses, lawyers, or others. D. The restriction of paragraph B and C do not preclude judges or lawyers from making legitimate references to the listed factors or similar factors when they are relevant to an issue in a proceeding. Well, first, before we establish any grounds for relevance, we need to establish the fucking record that these people are who they say they are, even though they're acting in a certain capacity. Under the Real ID Act, the fucking lawyer bringing the claim, making this fucking probable cause affidavit for suit, okay, first of all, he needs to sign as the power of attorney in fact for his client, okay? He needs to come in as the attorney of record, okay? And they're not doing it. You want to know how we know they're not doing it? Federal Rules of Civil Procedure, Rule 11B. States very conclusively that their full legal name must be used. Well, let's get it really clear here. Martin R. Klein is not his full fucking name. All right, his mother didn't name him Martin R. Klein. I don't know what R stands for. Maybe it's Martin Ruth Klein. Maybe it's Martin Ryan Klein. I don't know. I'm just jumping the gun on this, but I'm willing to bet and venture that the oath of office by that alleged public official isn't signed sufficiently under the Real ID Act using their full legal name. Rule 11 also states that nobody can bring a suit, legally speaking, without their full legal name being utilized. That way they don't have any plausible deniability, because we have to know who's accountable for their actions, right? They're going to try and shove it off onto the state using these false and misleading misnomers, these DBAs that aren't registered with the Secretary of State. They don't have a letter of good standing from the IRS to bring suit in the Union of States or the 50 states of the United States. They don't have a delegation of authority to operate outside of Washington, D.C., which is where all these crony little fucking rat lion weasel bastards should be, is in Washington, D.C. But they reach out their tentacles through contract. okay, through presumed and assumed contract, through legislation that doesn't apply to you and I, all right? So, I'm not saying some of their legislation isn't a good idea. When it's in harmony with the common law, I absolutely agree with it. You want to know why? Because I already abide by that law, which is the highest law in the land. And it's trust law. It's part of trust, okay? Real simple shit. Comment. A judge who manifests bias or prejudice in a proceeding impairs the fairness of the proceedings and brings the judiciary into disrepute. I'll call you back, brother. 2. Examples of manifestation of bias or prejudice include, but are not limited to, epithets, slurs, demanding nicknames, negative stereotyping, attempted humor based upon stereotypes, threatening, intimidation, or hostile acts. Is it your intent to be hostile to me? Is it your intent today to threaten, coerce, and deceive me from testifying? Is it your intent to prejudice my case by presuming and assuming that I don't know what the fuck I'm talking about, you half-wit son of a bitch? Okay? You see where this is going? Pay attention here. Hostile acts. When they're yelling at you, that's never, ever, ever recorded on the record. The stenographer doesn't go, oh, and the judge lost his temper. It's not a book that you're reading where you can see the emotion. The stenographer just puts the words down there. So when this alleged judge, this fucking bureaucrat, rat, bastard, communist piece of shit is over here trying to enforce his will upon you to unjustly enrich himself with his fucking bar attorney buddies, all right, it may behoove you to get that shit on the record. Is there a reason you're yelling at me today, sir? You sitting on the fucking bench acting like a judge, cross-dressing fucking Tweedledick motherfucker? Is there a reason you're yelling and creating insurrectious behavior and sedition? Is there a reason you're being hostile? Watch how quickly they backpedal. Oh, wait, no. I was just speaking up because, well, the sound system isn't very good in here, and I wanted to make sure you could hear me. Watch how quickly they cover their ass. And I'm speaking from fucking experience here. If you don't think for a second this is the type of shit I do in a court, you're absolutely fucking kidding yourself, all right? I call them on their bullshit every fucking turn of the way. Now, in the jury trial that we had the other day, I didn't call them on much bullshit. In fact, I was pretty fucking nice, but that's only because I have a plan in the background, okay? I could have been a whole lot more of a nightmare if I wanted to be, but I chose not to be because they've already put the fucking noose around their neck by being ignorant and willfully incompetent is my guess, okay? I think they actually know what they're doing, but they're being really fucking arrogant about it. And they don't think that the common man is intelligent enough to fucking fleece them financially. I'm going to show you it can be done. A judge who manifests bias or prejudice in a proceeding impairs the fairness of the proceeding and brings the judiciary into disrepute. We already covered that. A judge must avoid conduct that may reasonably and be perceived as prejudice or bias. 3. Harassment, as referred to in paragraph B and C, in verbal or physical conduct that denigrates or shows hostility or aversion toward a person on basis such as race, sex, gender, religion, national origin, ethnicity, disability, age, sexual orientation, material status, or political affiliation. And 4, sexual harassment includes, but is not limited to, sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature that is unwelcome. Let's go further. External influences on judicial conduct. Subsection 5302.4, external influences on judicial conduct. Again, we are going through the canons in Nebraska that the judges are bound by, okay? So if you're going to form your judicial complaint with the Bar Association or whatever, or the Judicial Committee for complaint against these agents and agency, it's important to understand what you're going to utilize. For a judge, you're going to use canons. For the Bar Association rats, you're going to use Federal Rules of Civil Procedure, so on and so forth. 5302.4, external influences or judicial conduct. A judge shall not be swayed by public clamor or fear or of criticism, B, a judge shall not permit family, social, political, financial, or other interest or relationships to influence the judge's judicial conduct or judgment. And C, a judge shall not convey or permit others to convey the impression that any person or organization is in a position to influence the judge. Well, let's hammer that one real quick. A bar association rat can go back in chambers and see the judge any time he fucking feels like. In fact, I just dealt with a special bar attorney assigned to a case who, as soon as he heard me in a court, decided he was going to waltz on back there and say, "Hi, Judge," as the door's shutting, as he's walking into fucking chambers, which I'm not privy to, all right? So that's called ex parte communication, and that's prejudicing the fucking case. And that makes him appear to be fucking biased, all right? Not non-biased, but biased. There should never be a fucking meeting that happens without you being right there in the fucking middle of it, period. And I don't give a shit if they're having tea and crumpets on the 9th fucking hole of the golf course. If they're doing business out there and they're talking about your fucking particular issue and subject matter, you should be there fucking period, all right? That means all their little backdoor deals and their fucking poker games in the bottom of their basement where they all are invited to their little private society fucking bullshit meetings where they decide what happens to you before you fucking even go to court. Believe me, that shit happens all the fucking time. Comment. An independent judiciary requires the judge decide cases according to the law and facts without regard to whether particular laws or litigants are popular or unpopular with the public, the media, the government officials, or the judge's friends or family. Confidence in the judiciary is eroded if judicial decision-making is perceived to be subject to inappropriate outside influence. All right? I've had that happen. I've had a judge who was cousins with another man who contacted him. Whether the subject was about me initially matters not, because what got back to me was they in fact had a phone call conversation and they did in fact talk about me, and that prejudiced my case. Period. I don't give a shit what anybody thinks about me. It's none of my fucking business. The fact is, the facts will always be the facts, and I'm a lawful man. I'm a law-abiding man, all right? I seek to cause nobody harm, damage, or loss, and I damn sure don't make up fucking shit to put on a fucking record and perjure myself to try and extort people and unjustly enrich myself like prosecuting attorneys do. All right. We are in Canon subsection 5302.5, competence, diligence, and cooperation. A judge shall perform the judicial and administrative duties completely and diligently. Okay, so completely and diligently, ladies and gentlemen. If you're bringing up the fact that you wish to depose the fucking actual claimant, the real party in interest, the man or woman bringing the claim, and they blatantly fucking ignore it, they just prejudiced your fucking case, didn't they? They just absconded from their fucking rights, titles, and duties, didn't they? And are they 100% fucking liable for their action? Yes, they are. But here's the kicker. Not as a judge, as a fucking private man. You can't sue a judge. The judge can't do anything wrong to you. The word judge is nothing more than a title of fucking nobility for an actor. You can't sue a judge. A judge did not fucking hurt you. There may be a man who at times acts like a judge who made an irrational decision, and if I find out it was so he could unjustly enrich himself, I'm going to nail his ass for extortion, RICO, racketeering violations, which is organized fucking crime with him and his fellow bar members, including the clerk of the court, who should have known. They had a duty to fucking know better, all right? But what they're doing in the judiciary in this day and age is they're testing everybody because, well, if we can steal from a few of them, let's say we can rob 1,000 and we only get caught by one who's intelligent and articulate enough to understand what we're doing, well, the juice is worth the squeeze. That's the reality of it, all right? That's what they're doing, which is bullshit, and that's not good faith. That's fucking bad faith. And every last one of these rat bastards shouldn't have a fucking pot to piss in. B, a judge shall cooperate with other judges and court officials in the administration of court business. 1. Comment. Competence in the performance of judicial duties requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary to perform a judge's responsibilities of office. Well, one of a judge's responsibilities of office is to take the true oath of office, the Article 6 oath of fucking office. I, to this day, have never found one administrator who has ever properly taken the Article 6 judicial oath of office. Not fucking one of them. 2. A judge should seek the necessary docket time, court staff, expertise, and resources to discharge all adjudicative and administrative responsibilities. 3. The prompt disposition of the court's business requires a judge to devote adequate time to judicial duties, to be punctual in attending, which I've walked out of a courtroom. Judge was 5 minutes fucking late, and I told him he could fly a fucking kite. See you later. This case is closed. It's sealed. You're in commercial dishonor. You're in breach of fucking trust. You're derelict in your fucking duty, and fuck you. Here's to me. You wasted my time, which is the most precious commodity anybody was ever gifted by the Heavenly Father, and I'll be fucking damned if I'm going to allow you to waste my fucking time. They then become responsible for the bonds and everything else because they're in breach of fucking contract, all right? Attending court and expeditious in determining matters under submission, and to take reasonable measures to ensure that the court officials, litigants, and their lawyers cooperate with the judge to that end. 4. In disposing of matters promptly and efficiently, not letting shit go on for 10 fucking years so you can run up the fucking financial clock over there. A judge must demonstrate due regard for the rights of the parties to be heard and to have issues resolved without unnecessary cost or delay. All right, that's denial of due process of law they're speaking of. Do not deny the men and women of this country due process of law when they challenge jurisdiction, and you fucking sit there on your fucking little pedestal and say, I've got jurisdiction. Get the fuck out of here, Cindy Lou. All right, you don't have jurisdiction because if you had it, I wouldn't be fucking challenging it. And now it must be produced on the record. You just merely uttering it from your fucking mouth does not constitute jurisdiction. All right? You got to know this shit, people. And you got to call them on their bullshit. All right, that is grounds right there for a suit against him, okay, in his private capacity. Sue the fucking shit out of him, because when you do this, it'll ding their fucking credit score, all right? It'll ding them. Their insurance policy will get a little curious about what this fucker really knows and what he's doing, all right? Now, how are we going to ding their insurance policy? Well, that's simple. That's really simple. You don't file a bar grievance, but with a judge, you're going to use the canons that they're supposed to abide by. And you're going to articulate in a statement of fact structured as an affidavit, sworn to under the pains and penalties of perjury, willing to testify and take the stand in an open court, as well as subject yourself to a polygraph. All right? You're willing to subject yourself to a polygraph. Now, I know what people are saying. Polygraphs really they're not adhered to in a court system. Well, here's the thing. If I stipulate to a polygraph and I take the fucking polygraph and he won't take the fucking polygraph, I fucking win. Period. All right? And it's not very hard to submit yourself to a fucking polygraph when you know damn good and well what they're doing in that courtroom is wrong. Okay? It's mixed war against the Constitution. It's extortion. It's baratray. It's theft by taking. It's securities fraud. It's tax evasion. When you know these things like I do, stipulating to a fucking polygraph test is the least of your fucking worries. Okay? You're going to send that off to the bar grievance division, and they're going to send you back this pre-scripted bullshit. This is a frivolous filing, but what they don't tell you is because you file a bar grievance against this judicial judge officer using the canon laws of the state for which he's in violation of or she's in violation of, they have to report it to their insurance company. When they report that to risk management because they have to, because a pending suit may be coming down the pipe, and the risk management will absolutely not be blindsided because some short dick asshole in a fucking dress didn't have the balls to inform them that he fucked up, all right? So this is how you nail these fuckers. Pay attention. We're moving on. Determining matters under submission and to take responsible measures to ensure that the court, officials, litigants, and lawyers cooperate with the judge to that end. In disposing of matters promptly and efficiently, a judge must demonstrate due regard for the rights of parties to be heard and to have issues resolved without unnecessary cost or delay. When we talk about unnecessary cost and delay, well, where the fuck is the plaintiff? No plaintiff has made a general appearance sworn to bonding this case. I believe none exist, and this case is immediately to be dismissed, vacated, with cause for want of prosecution, denial of due process of law, okay? And all those securities generated from this case are to be issued in bearer form paper. All the interest, all the dividends, the derivatives, because you already monetized it. You already put a Q-sip on the son of a bitch. It's already floating out there in the open market, and it's like a chocolate-covered turd that all the Saudi Arabian people are buying up, right? Or maybe just people from all over the world. I use Saudi Arabia a lot because the princes have a lot of influence in America. They like to buy securities out of America. So, let's move forward here. So is it unnecessarily delay when the judge doesn't do his part and step in and protect your unalienable rights and make sure that the man or woman bringing a claim or cause of action has come forward to testify or be deposed, right? Is he derelict in his duty? You're fucking A right he is. He had a duty to fucking know, and he absconded from it. Why? Well, because he really doesn't take an oath of office. This is a corporate takeover. This has absolutely jack shit to do with a true organic constitution, ladies and gentlemen. But that doesn't mean that you can't invoke the motherfucker and hold him to it. All right? A judge should monitor and supervise cases in ways that reduce or eliminate dilatory practices, avoidable delays, and unnecessary costs. Note, the Nebraska Supreme Court has adopted case progression standards at Nebraska CTR SS 6101 through 6104 and has adopted a rule, not a fucking law, a rule concerning the filing of cases under advertisement reports as set forth in Appendix B herein. Now, let's talk about pleadings. In order to actually file a real fucking claim, a real complaint, there must be a verified claimant. All the names must be properly identified. All the real parties and interest in the case must be properly fucking identified before the case can move forward. That never fucking happens. All right? So you're going to have to grab your sack of nuts, stand up like you got a pair, and say, fuck you, I'm not doing what you tell me until you produce the real party and interest so that I, as an honorable man, may be able to expedite this process and provide remedy to the shitbag who brought a falsified claim. Well, we'll say alleged false claim because we don't know. Maybe he really exists. Maybe somehow I did cause him harm, damage, and loss, and I was just unaware of it. It's plausible, I'll give you that. But until that shit stain shows up, all I've got here is a conspiracy against my unalienable rights by all you fucking learned people in law who had a duty to fucking know better. All right? Are you listening? Fuck. Try to help you guys out as best I can. And I know it's a struggle. I know my mouth sometimes is a little abrasive. But you know what? That's what it takes sometimes to get it through fucking people's head, because freedom isn't fucking free. If you think the founding fathers were a bunch of uppity, persnickety little fuckers that didn't cuss, that didn't tell people to go fuck themselves, you got another thing coming, all right? All right. Subsection 5302.6, ensuring the rights to be heard. Well, where is the right for the plaintiff to be heard? Where is it? You just kind of abscond from that, don't you? Well, the plaintiff brought a claim. Well, where is the plaintiff? The plaintiff's attorney wrote a fucking claim because the plaintiff is fucking imaginary, all right? Which means this dickhead who has no first-hand perfected superior knowledge at all of the facts, at all, mind you, which is why he won't get on the stand and fucking testify, because he's a lying, looting, pandering piece of shit. Look how fucking easy it is to rip these motherfuckers apart. If you don't think you have grounds for a suit for defamation of character, extortion, theft, conversion, I don't know what to tell you, Baratray's a fucking beautiful one, all right? They manufactured a scenario, and then under threat, duress, and coercion, you come in there because they say, if you don't come in here, we're going to send some gun-toting morons with an IQ less than 70 to come fucking arrest you, harass you, and drag your ass in here. All right, well, first, your claim needs to be brought under the Real ID Act. I need to know who the fuck you're talking to. And where is your warrant of attorney to represent those assholes. Are you listening? Are you paying the fuck attention? Because I didn't gain this knowledge overnight. It took years and years and years and years and years of reading their bullshit to figure all this out. And I'm trying to expedite your way of learning by breaking it to you in layman terms, all right? Without that real party in interest, without that man or woman being deposed, taking a stand, putting sufficient pleadings before the court, there is no probable cause for a warrant of arrest. There is no probable cause to create a court case, and all these lying, looting, pandering, fucking underling judges turn around and pretend that there is. Let me show you something. Tomorrow, I'm going to go bring a claim as Big Bird, and watch how fast they'll say, Big Bird doesn't exist. We're not going to be able to let you bring a claim. Sorry, I mean, where's Big Bird at? And do you have power of attorney to represent Big Bird? Sure do. Here's no power of attorney. Well, when can we meet your client so we can depose him? Watch how quickly they go, well, this is frivolous. We can't take this on. Yet, when they're bar cronies, they're brothers in fucking arms against the American people to fleece and extort and steal at a phenomenal fucking rate, like pirates on the land, Title 18, 1661, do the same thing. They go, oh, shit, yeah, George, we see it, son of a bitch. That's probable cause, affidavit. We don't need to know who your fucking client is. Bring him on in. Bring him on in. We got this shit. I'm going to show you guys how to fucking take these people's homes, boats, cars, fucking stamp collections, silver, whatever the fuck they have, they should be left destitute. Period. Destitute. All right? And everybody goes, oh, well, Derek, the judge surely wouldn't break the law. Yeah, he probably wouldn't if he wasn't fucking incentivized to, but they're fucking incentivized to break the law. All right? They're not honorable fucking people. And I just proved that in my own fucking case that went on without a fucking plaintiff making a general appearance, sworn to, bonding the fucking claim or complaint. I just fucking proved that. It's really fucking simple. It's a violation of the Sixth Amendment. It's a violation of my rights. The Sixth Amendment doesn't give me a right. It protects my fucking rights. And it tells these cronies, hey, there's a fucking line in the sand, and if you cross that line, you might lose your fucking testicles tomorrow. Be very, very, very careful about crossing that line. Are we saying you can't cross that line? No, we're not saying that you can't. We're saying that if you do cross that line, you are 100% on your fucking own, Scooter. All right? Welcome to Gilligan's Island, a 3-hour fucking tour. Subsection 5302.6, ensuring the rights to be heard. A judge shall accord to every person who has a legal interest in a proceeding or that person's lawyer the right to be heard according to the law. Well, I don't have a problem with that person's lawyer speaking, but that motherfucking lawyer better produce his fucking plaintiff, right? Okay. B, or that lawyer has lied. He's created perjury. He has manifested into existence a falsified fucking claim and is guilty of it and can go to fucking jail for it and be sued. B, a judge may encourage parties to proceed to a proceeding and their lawyers to settle matters in dispute, but shall not act in a manner to coerce any party into settlement. Now, what are they talking about that? They're talking about there's like an arbitration where both parties come into the court and the judge goes, ooh, God, that guy's kind of learned. I don't really want to put my testicles on the chopping block for this fucking attorney because I don't think he's got what it takes to nail this fucking dude. So, what do you say, boys? Would you like to go out in the hall and see if you can come out to some type of reasonable agreement? You can't? All right. Well, okay. If you can't, come back in here, and if this guy's slick enough, I'm going to have to nail your nuts to the wall, prosecutor, and you're going to have to break out your fucking checkbook and pay me for this, because I got to balance the books. I got a duty to balance the ledger. And so, as a trustee of these proceedings, you have to understand, lawyer, that if you can't produce your fucking claimant, sunshine, I'll take it out your ass. That's what they're really supposed to be doing, but they're not. They're not. Because they're unjustly enriching themselves with their bar crony friends because they have not done a rescission of signature or a rescission of contract or terminated the contract with the bar association they pledged a fucking allegiance to. Number one, The right to be heard is an essential component of a fair and impartial system of justice. Substantive rights of litigation can be protected only if procedures protecting the right to be heard are observed. 2, and again, these are the way that you're going to bring your bar grievance. Now, why would you bring a bar grievance for judicial misconduct by a judge? Because they're still a participating member of the fucking bar. They still have an active fucking bar card. All right, so we're going to let the Bar Association know. And you're also going to let the judicial community on rules and policies and shit know as well. All right, you're just going to have to look this up in your state. 2, the judge plays an important role. He's playing a role, ladies and gentlemen, in overseeing the settlement of disputes, but should be careful that efforts to further settlement do not undermine any party's rights to be heard according to the law. The judge should keep in mind the effect that the judge's participation in settlement discussion may have not only on the judge's own views of the case, but also on the perception of the lawyers and the parties if the case remains with the judge after settlement efforts are unsuccessful. Among the factors that the judge should consider when deciding upon an appropriate settlement practice for a case are: 1, whether the parties have requested or voluntarily consented to a certain level of participation by the judge in settlement discussions. 2, whether the parties and their counsel are relatively sophisticated in legal terms, and 3, whether the case will be tried by the judge or a jury, and 4, whether the parties participate with their counsel in settlement discussions, and 5, whether any parties are unrepresented by counsel, and 6, whether the matter is civil or criminal. They're always fucking civil unless you're federally indicted, and then it may be criminal. They're always civil unless there's a real party that is bringing forward a claim. Okay? So if it's civil, where's the contract? Oh, it's presumed and assumed. That's why the 12 presumptions of law are one of your best fucking friends to shut down court cases, because they're presuming and assuming that there's a contract. Well, you're going to refute and dispute that fact and say, produce the fucking contract or I'm going to hang you out to fucking dry for about 50 fucking grand. All right? 50 grand for wasting my fucking time. 3, judges must be mindful of the effect settlement discussion can have, not only on their objectivity and impartiality, but also on the appearance of their objectivity and impartiality. Despite a judge's best efforts, there may be instances when information obtained during settlement discussions could influence judges' decisions making during trial, and in such instances, the judge should consider whether disqualification may be appropriate. 4, mediation, which is really what they're doing when they're telling you to go out in the hall, is mediation. It's not so much arbitration, which is court ordered according to the law, does not constitute coercion within the meaning of this rule. It's a rule, again, not a law. 7, responsibility to decide. Subsection 5302.7 of the canon laws of Nebraska for judicial conduct. Responsibility to decide. A judge shall hear and decide matters assigned to the judge except when disqualified is required by Rule 2.11 or other law. Although there are times when disqualification is necessary to protect the rights of the litigants and preserve public confidence in the independence, integrity, and impartiality of the judiciary, judges must be available to decide matters that come before the courts. Unwarranted disqualifications may bring public disfavor to the court and to the judges personally. The dignity of the court, the judges' respect for fulfillment of judicial duties, and proper concerns for the burdens that may be imposed upon the judge's colleagues require that a judge not use disqualification to avoid cases that present difficult, controversial, or unpopular issues. Administrative reassignments for purposes of judicial efficiency is not prohibited by this rule. Boom, 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 boom. Number 8, decorum. Hold on a second, I gotta blow my fucking nose. Sometimes you just gotta hand them their ass, Wilson. You gotta get after it, Watson. You can't just stand around with your thumb up your ass. You actually gotta do a little fucking reading. And the American people fail miserably at fucking reading. Because a lot of the shit I teach comes right out of a fucking book. And I know people ain't reading that shit. Subsection 5302.8, decorum, demeanor, and communication with jurors. A judge shall require order and decorum in proceedings before the court. B, a judge shall be patient, dignified, and courteous to litigants, jurors, witnesses, lawyers, court staff, court officials, and others with whom the judge deals in an official capacity, and shall require similar conduct of lawyers, court staff, court officials, and others subject to the judge's discretion and control. C, a judge shall not commend or criticize jurors for their verdict other than in a court order or opinion in a proceeding. Comment. 1. The duty to hear all proceedings with patience and courtesy is not inconsistent with the duties imposed in Rule 2.5. To dispose promptly of the business of the court, judges can be efficient and businesslike while being patient and deliberate. 2. Commending or criticizing jurors for their verdict may imply a judicial expectation in future cases and may impair jurors' ability to be fair and impartial in subsequent cases. However, a judge may express appreciation to jurors for their service to the judicial system and the community, while they're all bullshitting them and hoodwinking them, which is what I saw at the end of the jury trial that I had. The judge said, well, thank you for being here before the holidays, and we appreciate your service to this court. It's all cockamamie horseshit. Thank you for helping us fucking enslave the rest of you dumbasses is basically what he's saying. For your willful fucking ignorance, for never applying yourself, for never reading the Constitution, understanding the Bill of Rights, looking into history and comprehending the Magna Carta. We thank you for your ignorance. Thank you so much for helping us extort this man of his rights. We really fucking appreciate you. That's what they're saying to you, basically. A judge should not commend or criticize jurors for the verdict or other than in the court orders or the opinion of the proceeding. Condemning or criticizing jurors for verdicts may imply a judicial expectation in the future. We already went through that. Number 3. A judge who is not otherwise prohibited by law from doing so may meet with jurors who choose to remain after trial, but should be careful not to discuss the merits of the case because you might let the fucking cat out of the bag. All right? That's what it is. When we come back, we will get into, no, we're going to do this one right now. Ex parte communication. All right? Ex parte communication, subsection 5302.9, ex parte communication. A judge shall not initiate, permit, or consider ex parte communication or consider other communications made to the judge outside of the presence of the parties or their lawyers concerning a pending or impending matter, except as follows. 1. When circumstances require ex parte communication for scheduling administrative or emergency purposes which does not address substantive matters is permitted, provided. A judge reasonably believes that no party will gain or procedural, substantive, or tactical advantage as a result of the ex parte communication. And B, the judge makes provisions promptly to notify all other parties of the substance of the ex parte communication and gives the parties an opportunity to respond. 2, a judge may obtain the written advice of a disinterested expert on the law applicable to a proceeding before the judge if the judge gives advance notice to the parties of the person to be consulted and the subject matter of the advice to be solicited, and affords the parties a reasonable opportunity to object and respond to the notice and to the advice received. 3, a judge may consult with the court staff and court officials whose functions are to aid the judge in carrying out the judge's adjudicative responsibilities, aka banking, or with other judges, provided the judge makes reasonable efforts to avoid receiving factual information that is not part of the record and does not abrogate the responsibilities personally to decide the matter. 4. A judge may, with the consent of the parties, confer separately with the parties and their lawyers in an effort to settle matters pending before the judge. 5. A judge may initiate, permit, or consider any ex parte communication when expressly authorized by law to do so. That would be when you're pleading the conflict of variance between the rules of equity and the rules of law, and it should be sealed in ex parte, and you need to show a cause why it isn't. Then you've got grounds for an ex parte hearing. 6. A judge may initiate, permit, or consider ex parte communication when serving on therapeutic or problem-solving courts, mental health courts, or drug courts if such communications are authorized by protocols known and consented to by the parties. In this capacity, judges may assume, which means they don't have the authority, a more interactive role with parties, treatment providers, probation officers, social workers, and others. Where's your power of attorney to do so? I want to know where you got it, how you got it, who gave it to you. 7. A judge may initiate, permit, or consider ex parte communications with persons supervising individuals placed on pretrial release programs or house arrest programs. Now, pretrial release programs and house arrest programs, ladies and gentlemen, are fucking contracts. Innocent until proven fucking guilty. But how many people walk into these stupid fucking shit shows and go, yeah, I'll go ahead and agree to a contract and do pretrial services. Fuck you! Prove your fucking claim or get the fuck out of my face. Real fucking simple. You gotta stand up and sound the fuck off. You gotta tell them to fuck off. I'm not gonna do what you tell me. But if you do want me to do those things, I'll conditionally accept your offer to fucking contract at $100 million fucking dollars paid up front today, right fucking now, and I'll go piss in your fucking cup. How you like them apples, motherfucker? Contract law, bitch. Yeah, I conditionally accept your offer under these grounds because involuntary servitude shall not be had, and I don't fucking work for free. How about that, motherfucker? Take that to the fucking bank and cash it, Jewish son of a bitch. D. Judges shall make reasonable efforts, including providing appropriate supervision to ensure that this rule is not violated by court staff, court officials, and others subject to the court's direction and control. All right, so when they're talking about the court did this, the court did that, the court did this, let me tell you something. You motherfuckers have to be fucking mentally incompetent if you honestly believe a court does a fucking thing. The court only serves one purpose, and that purpose is to play a motherfucking game. So you either get your head in the game, get your shit wired tight, your head on a swivel, and get ready to fucking go to battle with these motherfuckers, or fucking sign the fucking plea deal and go about your fucking way. But either way you go, I don't want to hear you bitching about, I gave it my all and they fucked me. Well, if they fucked you, I'm showing you how you turn around and flip the fucking game on their asses, all right? You want to get on a do not detain list? You better stand up and sound off like you got a motherfucking pair. You better bring out the fact that none of them have assumed business names registered as John D. Smith, all right? They're supposed to be using their full legal name, John Doe Smith, so we can affix full fucking liability to their ass for being lying, looting, pandering pieces of shit. They also need their fucking address, their phone number, and their fucking email attached to it as well. 100% in or you are 100% out. There is no in between, all right? And you got to call them on their fucking bullshit. Anyway, when we come back, we'll talk about the Real ID Act. We'll talk about the Federal Rules of Civil Procedure 11B, unregistered doing business as names, warrant of attorney, which grants them the ability to operate outside of Washington, D.C., which is where those motherfucking cretins have authority to operate, is there. Not here, not in the Union of States. They don't have any fucking authority here unless there's a contract. Malicious prosecution or action, civil liability penalties. All states have something similar. It's a tort, all right? Probable cause requires a party who has been caused harm, damage, or loss. I stay away from the word injury because it's a legal fucking thing. You'll always see injury attorneys on billboards and stuff. You will never see a harm attorney, a loss attorney, or a damage attorney on any fucking billboards. So the word injury, by its own definition, constitutes the legal society, okay? Federal Civil Rules Civil Procedure 17 their Article 1, Section 8 courts only apply to officers of the government. Are you an officer? Well, according to the FBI, if you write them, you've never sold alcohol, tobacco, or firearms, and you've never been gainfully employed by any of their fucking bureaucratic bullshit, okay? They're private organizations, and therefore, you're not an officer, period, all right? So, those Article 1, Section 8 courts are military tribunals where they're treating you as a mister or a miss, which is an egregious fucking misnomer because they're claiming that you're a party to their fucking construct, and you are not. Well, you should be the deciding factor of that, not me, all right? You need to know that. Article 6 violations must have an Article 6 oath. They must have an Article 6 oath, and they don't. They don't. And if they do, it's in that fucking misnomer, that unregistered misnomer is John D. Smith. Well, I'm sorry, Scooter. You didn't sign that with your full commercial and personal liability under the Real ID Act by signing your full legal name. So it's void, in ab initio. It is in fucking completo. All right? And I could go into the whole oath thing because there's a lot of shit they don't do fucking properly. For being learned at law, these motherfuckers are dumber than a box of fucking rocks. It's like, what the fuck did you really learn in law school? You can't even execute a fucking oath properly. That's insane to me, all right? They don't even do a statement of fact with their oath. They're supposed to file a statement of fact within 30 days about how they're going to execute their oath and they're going to honor their oath and blah, blah, blah. They never even do that shit fucking proper. Then they're supposed to bond. They don't ever get bonded. Under Title 26, 2032, AE 11, when they're doing commerce with us, baby, they're supposed to be fucking bonded with the Treasury, the Secretary of the Treasury in Puerto Rico. And none of them do that. I had so many lawyers come up to me and go, Derek, where the fuck did you learn that at? Because we never learned that in law school. Well, you mean to tell me you're admitting through omission or admission right now that you're not independently bonded with the Secretary of the Treasury in Puerto Rico for even handling this fucking matter, which means you have no proper standing, which means you don't have a letter of fucking standing from the IRS to even be here on this matter, and you're purported to be a collection agency on behalf of the United States Treasury. Are you fist fucking me right now, Watson? You are so fucked. Fucked. F-U-C-K-E-D. Fucked. That's how serious this shit is. I speak with passion. This is an anger, passion, so I hope this drives into your fucking heads. All right? Let's talk about Federal Rule of Civil Procedure Rule 8A2, a short and plain statement of the claim showing that the pleader is entitled to relief. Well, the lawyer may have done that for his imaginary fucking friend, but the problem is there are no sufficient pleadings. There's no affidavit that's been verified under the pains and penalties of perjury, signed before a notary, that I have caused anybody harm, damage, or loss, which means this fucking nincompoop, the prosecuting attorney on behalf of the state, who actually works on behalf of the county, who's actually working on behalf of a private banking organization and club, is actually committing fraud upon the fucking court. Are you listening to me? All right? So, we further go on because there was no notice and opportunity to me to remedy the situation because their fucking big bird imaginary fucking friend has never given me proper notice so I can remedy the situation, because I would, as a lawful man, I would remove the controversy by offering fucking remedy. But I can't offer remedy to an imaginary motherfucker. All right? Can't do it. I've tried. Lord knows I've tried. All right. Federal Rule of Civil Procedure 12B6. Failure to state a claim for which relief can be granted. And we support that. And Conley versus Gibson, USSC 1938, a complaint should be met, should not be dismissed for failure to state a claim for, unless it appears beyond doubt that the plaintiff cannot prove set of facts that would entitle him to relief. No contract. No fucking contract. How about the fact that the plaintiff hasn't made a general fucking appearance from day fucking one to even constitute a probable cause hearing, motherfuckers? Are you listening? Are you hearing that's the sound of fucking freedom right there. Knowledge is power. Knowledge is freedom from fucking oppression. All right? Yeah, I know. My mouth was just a little crazy today, isn't it? No plaintiff has made a general appearance sworn to independently bonding this case, submitting sufficient pleadings for which relief can be granted, and I believe none exists. Period. It's a matter of fucking law now. Judge, you make a fucking decision on this, and I mean right now, I want this fucking thing dismissed for want of prosecution, denial of due process of law, and for this motherfucker bringing fraud upon this court, I want him fucking sanctioned. I want him sanctioned on the grounds of Federal Rules of Civil Procedure 11B, Federal Rules Civil Procedure 17. I want him fucking prosecuted and sanctions brought against him for Federal Rules Civil Procedure Rule A82 because he knows damn good and fucking well he doesn't have any first-hand knowledge and Big Bird don't fucking exist. The state of confusion is not in his fucking favor. With that said, I love you guys. I hope this lights a fire under your ass and helps you out a little bit. As you can see, I'm not going to have a voice later on. But you got to get in there and tell these motherfucking halfwits how it is. Because they're going to run roughshod over you all fucking day long if you don't stand up and say, fuck you. That's the American way. It really is. One of my mentors said, Derek, you know how I close deals when I buy out corporations and I undercut them? I say fuck you with a multi-million-dollar smile and a handshake. Shouldn't you be the same? Smile in that motherfucker. I got your fucking nuts in a Conibear 30-30 bear trap, motherfucker. Make your fucking move. Make your move. Do something stupid today that enriches my life for eternity. Just make me fucking happy by violating canon laws, by violating the code of conduct, by agreeing with this piece of shit over here that there's somehow a cause of action. Just make my motherfucking day. Make my day. I'm gonna have fun with you. Yeah, you can lean these motherfuckers with the UCC one pretty easy. What are they gonna do? You can't lean me. We didn't do anything wrong. Oh, really? Well, you willing to testify to that? You willing to be deposed? You willing to go under the gun and do a polygraph test? How are your visual organs? Were you just unable to see that there was no man sitting next to the fucking plaintiff's attorney that day? Are you just that fucking stupid? Because you know what? If I bring a claim against somebody in a court and I don't fucking show up, guess what the judge does? Looks at the defendant and goes, what do you want the plaintiff to fucking pay you? What do you want done with this? The plaintiff didn't show up. Ball's in your court. What do you want? I'll give you whatever you want. You try that in their court when they're running their Article 1, Section 8 fucking military tribunal trying to allege that somehow you're a private in the fucking military. And they'll tell you to fuck off. You know what they can't prove? They can't prove jurisdiction. Why? Because jurisdiction requires a fucking contract. And that's why in the military, when you go before the USMCJ and they're telling you, hey, motherfucker, you're in breach of our code, you're in breach of conduct, and we're going to turn around and fucking bring suit against you, and we're gonna put penal sums against you and possibly incarcerate you, and you stand up and go, hey, prove to me you got jurisdiction to do that, and they turn around and go, did you sign that, Scooter? When you joined the U.S. military, did you sign that piece of paper? Is that your signature? Yeah, sit down and shut the fuck up. We got jurisdiction. When's the last time they've done that in a county court, district court, federal court for you guys? They never have, they never can, and they never fucking will. Love you guys. Hope this helps you out. We'll talk to you soon.